My name is Robert Goodwin, and this is Law on the Line. I would like to introduce my guest for this segment, who is Alex Kemeny. Alex is the managing partner of a law firm of Kemeny, Ramp, and Renault, located in East Brunswick. And Alex is also an adjunct professor of law at Rutgers Law School, and he's currently teaching a course on appellate advocacy. I'd like to welcome you aboard to Law on the Line, Alex.
Thanks so much for having me, Bob.
My pleasure. And today's topic is going to be something that is related to your teaching at the law school, but gearing it to our general audience, and that is how to advocate like an attorney. And when you're in law school, you're teaching to be attorneys, and you want them to learn how to advocate like an attorney. So tonight, or at this session, we're talking to primarily folks who are going to be in court who are self-represented. And you also told me something earlier that in current law school curriculum, there is training in such advocacy programs that, quite frankly, didn't exist when I was in school. So tell me, what is being taught in law school, and when we discuss this somewhat esoteric term, advocacy?
So when it comes to advocacy and law school, people think that law school is quite a bit about learning what the law is so that you can go out as an attorney and be an expert in the law. And the advocacy comes not even second or third, but somewhere eventually down the line. In fact, though, what law schools have begun to realize over the years is that the advocacy skills that their students are able to develop in law school and to take into practice are critically important for their success. It's not simply as an attorney that you are supposed to be an expert in the law or a particular area of the law, but it's important for you to understand how to advocate and how to communicate on behalf of your client.
Now, we're talking about someone who is listening to this show and may be involved in litigation where it could even be small claims court or municipal court for that matter, where they are their own attorney, they're their advocate. And what are the skill sets that you want to communicate, you want to convey to them as to the, maybe for lack of a better term, the art of advocacy?
So believe it or not, one of the first things that they want to do is they want to think about what's their objective and what's the point that they're looking to make. There is a book, 7 Habits of Highly Effective People, that a lot of people are aware of. And one of those effective habits is keeping the end in mind. And that's something that people often don't do when they're showing up to court. They realize that they're going in for a particular reason. They might understand what they're looking to accomplish, but it's important for them to first articulate what are they asking the court to do or not to do. And they want to start building their argument around that. Then there's certain things that they teach you in a lot of law schools. I know particularly at Rutgers, they've got a fair amount in the first year where they will talk to the students about 3 principles of advocacy that Aristotle used to use.
And what are they?
These include ethos, pathos, and logos. Ethos is really the idea of credibility. You want to make sure that your argument is credible. That means that the sources that you're using are credible, that you're believable, and that whoever your audience is, whether it's a judge sitting in a courthouse or in some other setting, finds that the argument you're presenting is one that they can believe in, whether it's because they can believe you or because the sources that you're using as the foundation of your argument are sources that can be trusted.
Reliable sources.
Correct.
So what is pathos?
So pathos is the idea of emotion. Often we think that emotion should have nothing to do with the law. The judge is there to make a decision based upon what's right and what's wrong. And certainly judges try to do that. But there is a component of the story that you're telling that's going to have an effect on the judge or a jury, and you want to be able to present your case in a way that's going to make whoever has to make the decision ultimately want to make the decision in your favor. And so being able to tell a story a true story, but nonetheless a story that the person can understand and empathize with, it can be critical in the ultimate determination of your case.
And lastly,
Logos. So logos is logic. And that's the one that I think most people realize is important, but people don't always understand how difficult it can be to craft a logical argument. When they're thinking about it, they've got an idea in their head, it makes sense to them, but then when it's time to explain what the argument is, people wind up having a lot more problems than they anticipate. Just because something's in your head and it's clear to you doesn't mean it's going to be clear to the audience. There's a lot of things that you know that the judge doesn't know, that the jury doesn't know, and it's important that you go through your argument and that you are able to sort of put each piece together so that the audience is able to follow where you're going and there's a clear path from one point to the other.
And you used, and I believe in law school, an acronym to sort of describe the process of which you would identify an issue or issues in a particular set of facts. And I recall from law school way back when, IRAC, and I'd never heard of CRAC, and that is CRAC, or is that what it's called?
Yeah, so different law schools have different acronyms and slightly different methods that they teach first-year students when it comes to legal writing. But in almost every law school, there will be some version of IRAC or CRAC that is taught.
And what does that mean? What is the acronym for IRAC? And then we could go into CRAC.
Sure. So IRAC is issue, rule, application, conclusion. Issue meaning what's the problem that has to be decided, or what's the question that needs to be decided? What's the rule, or what's the applicable law? Application is the application of the rule to the particular set of facts or circumstances in the case. And conclusion is the conclusion that you'd reach after applying the rule of law to the relevant set of facts.
And that's the conclusion you want the court to reach in your argument.
Correct. And there's a reason why there's that formula of writing that is taught in law school. It helps law students and then future attorneys organize their writing in a way that makes the writing clearer and easier to understand. One of the first things you want to make sure you're doing when you have an argument or you're trying to convince someone of something is to make sure that you're being understood. If the person can't follow what you're saying and they don't understand your argument, it's very unlikely that you're going to make any headway with it.
So this applies both to a written document or perhaps a brief that one is writing, but what about the oral presentation that a potential litigant, self-represented, is seeking to make in a court before a judge, or for that matter, and rarely before a jury, but particularly in special civil part, small claims court, let's use that as an example, where it's all oral and very little in writing. How would a person present an argument using that IRAC approach as a short-hand acronym so they could focus on the issues?
So we spoke about IRAC. There's also CRAC, which is almost the same, except you're starting with your conclusion, as opposed to just simply identifying the issue. Then you provide the rule. Then there's the application and the conclusion again. And I prefer that in most circumstances when I'm trying to advocate with the court, whether it's in writing or in person, so that the judge knows what's the conclusion that I'm looking for the judge to make. And it's very helpful to have an organized argument that you can present, that you've thought out. I don't suggest that you necessarily write out the entire argument, but having an outline that you can follow can be very useful. But I want to caution people about that because written advocacy and oral advocacy are very different. When you're in the courtroom, there's a judge that's probably going to have some questions for you. And you want to be able to engage in that dialogue and to understand and to listen to the judge, because the judge will let you know what he or she is concerned about and will let you know what are the things that they think is important for their decision making. Now, there might be other things that they need to know about that you need to articulate, but you certainly don't want to ignore their questions, even accidentally, as you're focused on trying to explain what you're focused on trying to explain.
So let's use for an example a landlord-tenant scenario, and the tenant believes that the landlord has improperly withheld his or her security deposit. And now the landlord is in small claims court to recover a $3,000 security deposit as a hypothetical. And they're pretty common cases. When the tenant litigant, self-represented, is seeking to present his argument, how would that uncomplicated argument, but very important, be approached using the CRAC methodology?
So one of the things, one of the reasons why I generally suggest to people that they hire an attorney if they can is because often you're not going to be familiar with the applicable law.
True, true.
Here in landlord-tenant court, when it comes to a security deposit, you're fortunate enough that the judge is going to be pretty aware of the applicable law, and you won't have to educate the judge on that. But you're going to want to be able to come in, first tell the judge what's your conclusion, which is that I'm owed this much money back from the landlord in terms of a security deposit. Okay, what's the rule? Can you point to a source of law? Can you point to something else that says it needs to be returned? In this situation, the court actually has a self-help guide, and there's information that's available.
Correct.
And then you want to apply it to the particular set of circumstances here. And you're going to want to be able to show how much is owed. Now, that might sound simple, but you don't want to forget to bring in the documents that you need. Is there a lease agreement that shows that you were supposed to pay a security deposit? Do you have a copy of a canceled check or a receipt that showed that you paid the security deposit? What are the things that you need to be able to show to the judge to prove to the judge that you paid the deposit, that it hasn't been paid back to you, and that there is a certain amount that should be returned?
So you obviously want to present your argument in the best light available to your argument. And in our prep for tonight, or this session, you mentioned something that don't ignore, you the litigant who is a proponent of the position that you're entitled to the return of the security deposit, plus perhaps any applicable damages, double the security deposit in the state of New Jersey. And what about, as you said, don't ignore the adverse facts in your presentation? And for example, an adverse fact may be you caused damage to the apartment.
So you want to make sure that you address those things, because the judge is going to probably have some questions. And if you don't bring that issue up, your adversary, in this case the landlord, is likely to bring them up. So for instance, if there is a problem where there was some damage that was caused, you want to get in front of it. You want to acknowledge that there was some damage, but maybe that the damage that was created wasn't very much. You know, there was a deposit of $2,500 that the landlord should have been returning to me. And yes, there was a small hole that was accidentally left, but it's something that could have easily been patched. And there is law with regards to the landlord's requirement to notify you how they're going to be using the security deposit, if they're going to be using it, requirements in terms of when they've got to return it. You want to be familiar with those things, and you want to also be able to say, Judge, even if I might have caused some damage, that's not a reason for him to withhold the entire security deposit. You
also said something interesting, you know, when you said meeting a problem head on and you know, evaluating how you would meet that problem. And you use an example of a will, and where a beneficiary of a will who is seeking to enforce the will, and there's a will contest brought by perhaps family members. Explain that a little bit further so people understand how you can meet a problem that you're confronting head on.
So some of the work that I do, actually a large portion of it is probate litigation, estate litigation, and it's not uncommon for us to see situations where there is a will that has favored one child over another, or possibly one child has been cut out. And sometimes what has happened is that there's been one child that really had an opportunity to influence mom or dad before the will was made, because they were helping to take care of mom or dad. Maybe the last few years of mom's life, she was declining. Her memory was much worse. She had a lot of physical ailments, and this child was the one that was essentially in control of the finances, was paying the bills for mom, was taking mom to the doctor, and really had a position where this particular child could pressure mom to make decisions that mom would not have made in prior years. And on the one hand, you've got an individual seeking to contest the will that can point to those circumstances and say, look at all this opportunity of my sibling to have unfairly pressured mom into changing her will.
Based upon their relationship at the time.
Based upon the relationship. And there's 3 other wills that we have from mom where she had kept everything the same. And why did mom change it now? It's because
to exclude us, perhaps, or give us a lesser share.
It's because my sibling pressured mom while she was weak and while she needed help to change her will, and I was living out of state, and that's why mom did it. Mom would have never done that if she would have not been pressured into doing so. And that's certainly an understandable argument. But a lot of those same set of facts might be the exact reason why mom freely chose to change her will. Listen, mom understands that I've got a child that's living out of state. Generally speaking, I'd like to favor both of my children equally. But this particular child went above and beyond in terms of taking care of me. We got much closer in the last years of our life, last years of my life, is something that mom might have been thinking about. And it's quite possible that the parent wanted to favor a particular child because the child set aside a tremendous amount of time, sometimes at a significant personal expense, to help take care of the parent. So you sometimes have the same set of facts that can be used one way to say that there's a problem, and sometimes you can take those facts and explain why they're actually helpful to your argument. That's not always the case. Sometimes you've just got difficult facts. But in those situations, it's important also to acknowledge them and just say, well, you've got these facts. These other facts are more important. You should.
Now, you also pointed out that in terms of being able to persuade the trier of fact of your position in an argument that you're presenting, or in the course of the case, you talked about credibility, emotion, and logic. And that's the ethos, pathos, and logos. And that is, in plain English, credibility, emotion, and logic. Can a litigant, or should a litigant, who is representing themselves assume that the court would help them with not the logic so much, but and perhaps it is with the law of the case? When landlord-tenant, perhaps a little bit, you've already answered that question. The judge is fully familiar with the law. But in a will contest, perhaps the law is not quite so clear. How would you guide somebody who is advocating like an attorney?
So generally speaking, I find that judges are human beings, and most human beings want to make the correct decision. They want to do the right thing. And judges are often familiar with a lot of the applicable law, but none of us know all of the law.
No, for sure.
And there are certain resources that you can go to, to research the particular law that you might need to rely upon. But I wouldn't assume that the judge necessarily knows all of the law that might be applicable to your case. In fact, in most situations, they're not going to know all of the law. They'll know most of the relevant law, hopefully. But we're fortunate that it used to be that you either needed to go to an expert or you needed to spend a lot of time in the library. And today, while I wouldn't suggest that Google is the beginning and the end of where to look, there's a lot of resources that are available online. And the court itself has a number of self-help guides that are available to litigants.
And to assist litigants.
Correct. And so there's resources out there that people can look to if they're trying to determine what the law is. And I'm going to let you in and the audience in on a little secret, which is that a lot of attorneys nowadays will often start some of their research with Google. They'll be able to do it a lot better than the average person, because they'll have familiarity with what the law is generally, what to look for, where to look, and what are credible sources. But it's a very powerful tool when you're trying to at least get started on your research.
You mentioned also, in terms of the skill of advocacy, is keeping things concise by cutting out the extraneous. Now, you're not an attorney. What advice would you give a pro se litigant about how to, or knowing how to, cutting out the extraneous and focusing on that which is important?
So we talked before about first thinking about what your goal is. Keeping the goal in mind. You want to do that, and then craft your argument around that. What do you need in order to make that argument and to convince the judge? Very often I will see unrepresented parties talking to the judge about the particular situation and giving details that aren't relevant to the decision that the judge ultimately needs to make. There may have been a lot of unfairness, a lot of things for you to complain about and to be upset about, but those aren't always relevant to the determination as to whether or not you should get your security deposit back, for instance, or whether mom was unduly influenced when she executed her will. So as you're crafting your argument and you're thinking about what are you going to say or what are you going to write, you want to keep thinking about whether or not the point that you're making helps you get to your ultimate goal. And if it doesn't, take it out. Don't say it.
That's the extraneous.
That's the extraneous.
I always learned, or used what I learned, and somebody once said, you always have to think about the theme of your case. And I think that's what we're really talking about. What is your goal? When you enter into the courtroom on a case that is litigated, when and how do you develop the theme of your case?
So I will develop the theme of the case long before I walk into the courtroom.
That's what I thought you were going to say.
As soon as I meet the client, I'm trying to determine a few things. One of the first things I'm trying to determine is what are the client's goals? And you'd be surprised at how often clients will come in and tell me that their goals are X, Y, and Z, and they're not. What they're telling me is the means by which they think they can achieve their goals, but it turns out very often that what they're looking to achieve is a little bit different from what they will initially tell me. What do I mean by that? They might tell me that they need, for instance, a contract that says something because they're looking to, accomplish this particular goal. And it turns out that that's not exactly what they need. They may need a different contract, or they might already have something that's enforceable. There may already be an enforceable agreement. So I always try to figure out what are the actual goals, and then how are we going to get there. Once I know where we are going, I try to develop that theme that you spoke about, where there is a story and a narrative that will help get the audience to reach the conclusion that the client wants.
Good. I want to change it a little bit from the art of advocacy in terms of what we say in the courtroom or what we write, but how we present ourselves in a court of law or in any posture or circumstance where we're trying to make a convincing argument. What I mean is body language, the manner in which you speak to a judge. What tips do you have for our audience on that?
So every situation that you're in is different in terms of what's expected of people. If you go to church, if you go to a synagogue or to a mosque, you'll see people are typically dressed a certain way, particularly on certain days, and that's going to be certainly different than you'd see people at the pool. Same thing is true of court. There's a certain expectation that the court has, that judges have, in terms of how you dressed, how you behave. You want to show deference to the court. You want to dress appropriately. What does that mean? As attorneys, we sort of have a uniform. It's very easy for me. I know I'm going to court. I've got a suit, a tie. For a pro se litigant, someone that's not represented, I don't think that they necessarily need a suit and tie, but they want to demonstrate that they understand the importance of what they're doing and that they're dressed, professionally and showing that they're taking it serious. They want to speak with deference to the judge. They really want to understand the circumstances where they're in.
No, which is obviously very important. So you're not an advocate of coming to court with cut-off jeans and with holes in, your leggings or whatever that may be. I would imagine, and now we only have a few seconds left, but with Zoom, how should a person present themselves on Zoom when you're physically not in the court? And it's a little bit more difficult for a judge to capture perhaps the emotion that you have, the ethos that you were talking about.
So I would suggest that you try to have yourself in a room where there's nothing that's going to be distracting. There's nothing in the background. You're dressed appropriately as though you were in court itself, and that you don't have things that could be distracting to the judge while you're on Zoom, and you don't do other things while you're on Zoom. You pay attention to what's going on so that you're giving that sense that you're taking things seriously, and there's nothing to distract the judge from the points you're trying to make.
And no eating, smoking, and the like.
Correct, because it shows a lack of respect, or at least it can be interpreted that way by the judge, and you never know what's going on in the judge's mind. The best thing, the most you can do is take a best guess. And two, it's distracting. So even if the judge doesn't think that the person's being disrespectful, they may be paying attention more to your sandwich than the point you're trying to make.
And also maybe to that third party that may be in the room, or other party that may be in the Zoom room that you're not which you're constantly turning your head and looking at.
Correct.
I guess the key here is understanding your audience and being able to present your case to that audience. And I think that your future attorneys that you're teaching in law school are learning very well from you as to how to tailor their arguments to that future judge, that they will be meeting as future lawyers. So I thank you very much for, giving our audience here today a very interesting point of view concerning the art of advocacy, and not dealing necessarily with a specific area of the law, but the general means by which we can convey and communicate to the court. So I thank you.
Thank you very much for having me.
My pleasure.